The court makes its determination about whether or not someone qualifies for involuntary treatment under the Marchman Act by looking at what evidence is presented to the court. At the assessment phase, they primarily rely upon the affidavit and sworn testimony and other facts submitted on an emergency basis, but sometimes can require a hearing even for that phase. And thereafter, at the final hearing, we're asking whether or not the patient can be involuntarily committed to up to 90 days. The court is considering all evidence that is presented, primarily information that comes from an expert testimony, and the written assessment completed by a qualified professional is going to be heavily weighed in favor of establishing whether or not the elements are met. Again, there are specific elements that are legal in nature that we can talk a little bit more about in a different video here. What's important to recognize is that as long as the facts and evidence are substantial, that the individual has a substance use disorder, has had a prior history of being noncompliant with treatment in the past, and is unwilling to voluntarily participate in treatment as recommended by the facility, you have a good case to be considered, and you should reach out to an attorney to learn more about whether or not the court would grant that.